right, this is going to be rambly because it's just going to be rambly. All right, the hearing. I listened to it. It was boring. It was a bunch of discovery stuff. So they're going to extend the deadline for fact discovery to the same deadline as for expert discovery. Usually you have fact discovery first because the expert witnesses need to rely on the fact discovery to form their opinions. But because they all need more time, they've decided they're just going to have them be the same. We'll see if that works out. Sometimes it does, and sometimes it doesn't. But when you extend the fact discovery deadline, you then have to back up all the deadlines that come before it, right? Because when discovery is over, you can't have outstanding issues, you can't have outstanding productions, you can't have outstanding depositions. When it ends, it ends. And people have to know when it ends so that they can start figuring out if they're going to file motions for summary judgment, which is the next thing. And I'll talk about that when we get a little closer. So what the judge said today was, if we've got this end of September discovery cutoff, we now have to back up all of the deadlines before that because you want to have all discovery disputes filed and ruled on so that you know what information you have so that you can finish out the depositions before the discovery deadline. Because that discovery deadline is very much like a cutoff. Like, once that day comes, you can't send interrogatories, you can't send requests for production, you can't send subpoenas, you can't schedule depots, like done is done. And so you have to back everything up. A lot of litigation at this point in the discovery process is scheduling. There's a ton of scheduling. So from what I heard, we're probably going to have a flurry of discovery dispute motions in the next couple of weeks because the judge said for any outstanding document requests as of right now that are out there, if you haven't gotten what you wanted, I want motions to compel on those by August 1st at the latest. And then the responses to those will be due 4 days later on August 5th. So that means that whatever's, I know there's, I think Wayfair has an outstanding motion to compel on Lively's damages that they're currently fighting over, but he's saying anything else is outstanding like that. I want you to file those motions to compel by August the 1st so that I can deal with them so that you'll know where we're going from there. And then you'll have the next month and a half, 2 months to finish your discovery. August 15th will be the absolute drop dead documents that go to fact discovery deadline for production. And then if you don't get what you want by August 15th, you can file a motion to compel by August 22nd, and then we'll have responses on August 26th. So he's basically setting them up to say, I want all the discovery disputes on the table as fast as you can get them, and at the very latest, by these dates, I'm going to turn them, I'm going to rule on them, so that when you get to the end of fact discovery, when you get to late August and September, you can take your depositions and you know exactly what you can and cannot have. There were no really fireworks. Like Kevin Fritz did try to bring up the Google subpoenas a little, and the judge was like, he said, listen, everyone will have their opportunity to argue their facts of the case. And he said, and I thought this was wise of him to say because he knew the public was listening, I know that you all have very different interpretations of what the facts are, and you're going to all have your opportunity to argue what the facts are. But today I just want to talk about scheduling, which was fine. The only other thing that I got out of that hearing that was interesting was Jed Wallace's lawyer was also there. And they were talking about, do these deadlines work for everyone? And everyone pretty much agreed. And then the judge asked Jed Wallace's lawyer, said, does this work for you? And Jed Wallace's lawyer said, yeah, that works fine for us because we've provided every document we've been asked for. We're done. So that's interesting to know. On the issue of the Google subpoenas, I've been thinking about it more today, and I love you guys' comments because you make me think about this more. I'm not going to think about it at the level I would if it was my own case because I do this for free. But in terms of thinking through the issues, you guys really help because you ask really good questions. And I think for me, where this is going to turn, does California law apply and where do you file the motion to quash and all that kind of stuff. But I think for me, where this probably will end up turning is, because a lot of you have said, is this a fishing expedition? And that's a question, of course, that comes up in discovery disputes all the time. Are they just looking for something with no real reasonable basis for believing that it's there? And if the lively party's argument is our only basis for thinking that these content creators are in cahoots with or have been paid by Wayfarer or their lawyers is the fact that they say bad stuff about Blake Lively, I don't think that that's enough. That's where the speech thing, right? If your speech is the only basis for it, to me, that's where the line is. If they have another basis for it, like they've gotten anonymous tips that these people are in cahoots, or somebody has disclosed to them in other discovery that these are content creators that they know and communicate with regularly, or if they've got a phone log from Friedman's office and it shows who he calls. I mean, that's probably not happening because that's privileged, but if there is some other basis that's like, hey, we have reason to believe they're discoverable information here, then I think that's probably a better chance for them to get it. If they say the only reason we think they might have this information is because they're saying things about us that we don't like, that to me is where the First Amendment comes in. Because you shouldn't be able to subpoena somebody simply because they have made public statements about you in a public forum in a public dispute that you don't think are flattering. I also want to be clear, and it's funny how everything comes back around, that, so people have said, like, this is so scary because anybody can come and get your information. I want to be clear that nobody could just like do a request to Google and be like, hey, can I please have not actually Golden's information, right? Like the reason that Google is evidently notifying people is because they've gotten legal process, and that creates obligations on their part. But what's tricky about this one is you're only able to send a subpoena if you are involved in a court dispute or otherwise have subpoena power like some government offices have, right? So being in a dispute gives the lawyer subpoena power to order the turnover of this records that a regular citizen couldn't do. So the subpoena makes the argument harder for the recipient to say no to, because now they have to balance the privacy of their users and their own policies versus a court order. And this is why the Van Zandt thing is such a big deal. Because they knew that if it had the flavor of legitimacy on it, it would allow Stephanie Jones to say, oh, I had a court order. There was nothing I could do. It was a court order. But the case wasn't real. So that's why that thing continues to be a lot of our Roman empires, is that, yes, as a litigant in a civil matter, you do get subpoena power and you are allowed to subpoena third parties for information that might be relevant to your case. But what happens when the case that gives you the power isn't really a case that you're pursuing? And what happens if the case that gives you the power is a case by which, yes, you have prima facie valid retaliation claims, but you have no other basis to believe that the third parties you've subpoenaed are involved other than things they have said while they were exercising their right to free speech? It's all the same. It's all part and parcel of the same issue, which I did listen to Molly McPherson, and she is 100% right. Because people know enough about these things, especially in 2025, to know what feels wrong.